Good morning, everybody. We'll get started in just 2 minutes. Everybody is filtering in. Please make sure you're checking the chat option. There's some information in there for you. As soon as the button stops rolling, we'll get going here. All right, everybody. Welcome to today's presentation. Just a few housekeeping things. There's over 100 parent centers in our great nation. Parent centers, of course, help families anywhere with children ages 0 to 26. We are funded partially by the U.S. Department of Education under IDEA to provide supports for families and understanding their role in special education. Family Matters is unable to offer CEUs for participants. However, you can request a certificate of attendance after you complete your survey today. We are not a legal service. We do not provide legal representation in any way. No information we share with you or are shared during our presentation should be considered as legal advice. As I stated before, we are partially funded under the U.S. Department of Education. However, the contents of today's presentation don't necessarily represent the policies of the U.S. Department of Education. The webinar is being recorded, and the recording will be available on the Family Matters website. At this time, we ask that you sign in with the chat box listing your name and your title or organization. So, for example, if my name is Abby and I'm a parent of a student with a IEP plan, I would say Abby Parent. If you're professional, same concept. Please make sure you're limiting your questions to the Q&A box. It makes it easier at the end of our presentation to find those questions and go over them with our presenter. Make sure you're completing your brief survey that will be following this presentation. Is very short. We need this for grant-funded purpose. We are a grant-funded organization and need to collect our surveys for our grant. A copy of the presentation was emailed to you yesterday as far as a link to find the slides. It's also listed in the chat. You can find a copy of the slides and the handouts associated with today's presentation there. Family Matters is, of course, the state's parent training and information center that serves 94 counties of the state. The other counties served are in the Chicagoland area by FRCD. We carry all these different programs. I don't want to spend too much time focusing on them today because Laura's got a wonderful presentation, and I want to make sure she gets through it. I do want to mention that our Compass, Coaching Others and Mentoring Parents About School Services program will launch in 2025. So if you're interested in that, please make sure you're following information on our website. As always, the state is always in great need of educational surrogate parents. We offer the training program for that. If you're interested in finding out more information, let us know. Our transition news last went out yesterday. It focuses on small family-owned businesses in Illinois employing individuals with disabilities. I would highly suggest you check it out. And of course, we have our monthly podcast. Okay, I'm going to switch my sharing of the screen and try to remember how to put it in presentation mode. So many different things here. No. Okay, let's start. Go ahead and get started, Laura, and I will remember how to do this eventually. If someone remembers how to do it in the chat, you are welcome to put it in the chat.
We need all the help we can get.
Yeah, we do.
Good morning. My name is Laura Hart. I'm a special education rights manager with the Human Rights Authority, which is a division of the Illinois Guardianship and Advocacy Commission. I do special education advocacy as part of my role, but I am not an attorney, so nothing discussed today should be interpreted as legal advice. If you do want to discuss your personal situation with an advocate or an attorney, please feel free to call us at the 1-800 number that's on the second slide there. We're happy to try and answer your individual questions on that call. But if you have generalized questions for me today as the presentation goes on, go ahead and put them in the chat, and then Abby will read those to me when we are done with the presentation. Also, I speak very quickly because I have a lot to get through. So if anyone can't hear me okay, or if you need me to slow down or repeat anything, please put that in the chat too. I'm not offended in any way if you need me to stop and review something. So just let me know. All right, so the Guardianship and Advocacy Commission is a state agency. We are actually run by a board of commissioners that are appointed by the governor, and we have 4 primary programs. The first program listed here is the one that most of you are probably familiar with, and that is the Office of State Guardian. We are guardian of last resort for adults with disabilities. So what that means is if someone needs a guardian and does not have anyone available to be appointed as their guardian, the court appoints the state. In that case, the office, the Office of State Guardian would be appointed and they would manage that. The second program is Legal Advocacy Services. They provide legal advice and representation for both children and adults with disabilities. The primary role that our LAS program facilitates is mental health commitment. So those individuals who have been involuntarily committed into a hospital and need representation for that process. We have the Human Rights Authority, which is investigations of rights violations. It's an amazing program where we can go in and we can investigate any provider as long as there's an individual with a disability and a potential rights violation outside of abuse and neglect. So we take all variety of cases with the HRA. The goal is for us to make systemic change. So policy, procedure, go in and see what's going on. That helps the individual who the case is related to, but essentially we want to make sure that doesn't happen again. And so we're able to put different things in place. That's a very lengthy process. It's designed to be. I stand behind that lengthy process, changing policies and procedures and getting, places trained on correct policies and procedures is not a quick fix. So many years ago, we were seeing an increase in special education cases because a school would be a disability service provider. And so we knew that we needed to get some of our staff trained. I promise I'll slow down a little bit so you can understand. Our staff trained on the laws that we need for special education, and we needed kind of a quicker process in order to get students and parents the information and assistance that they needed as part of special education quicker than we would be able to do under those investigation processes. And so because of that, we developed the Special Education Collaborative that is both the Human Rights Authority and Legal Advocacy Services. And we broke things down into 3 categories that we could provide services for. So the first one is special education training and information. That is exactly what it sounds like. I take lots of calls every single day, just asking questions from schools, questions from providers, questions from parents, sometimes students, asking about what the policies and procedures for special education would be. We also offer trainings like this one. We help create training. If there is a lack of training, we work very closely with Family Matters because they have amazing trainings. That's kind of how I'm here today. The second area that we offer services in is actual advocacy. It's a more formal process. We do an intake. We talk to a family about what they need, what the potential law violation might be, what's going on, and how we can best support that family. And so everything that I'm going to talk about today really comes from this perspective of the special education advocacy program, because I think that it's easiest if I present how I process this. So how I would go about looking at procedural safeguards, how I would go about looking at dispute resolution from an advocacy perspective. So keep that in mind when we're going through these, that you are really getting kind of a glimpse into how I look at cases when they come into me and we get to the point where we need to utilize procedural safeguards or train families or providers or districts on what those might look like as well. We also offer services in a third area, and that's legal guidance. And so when we are to the point in the presentation today where we get to mediation and due process, we know when we're talking with families about that Illinois has the availability for parents to represent themselves if needed. And that's a wonderful tool. It can sometimes be money saving. However, you are over 70% more likely to be successful in dispute resolution if you are represented by an attorney. And we know that that is not easily accessible. There are not very many attorneys across the state who are well versed in those processes. And also we know that it can be expensive. And so we offer some legal services specific to mediation and due process. So if you were on my caseload and I was providing advocacy to you, and we got to the point where we were seriously considering mediation or due process, we have gone through all the other things that we're going to speak of today, and that's really where a parent is, then we would refer them over to our LAS program to get support from an attorney and paralegal. All right, the next slide here goes through special education laws. I just truly believe that if people know the core of where the information I'm giving them comes from, that they are going to be able to look things up and understand more and seek out more information. And so when I'm answering questions as part of that information and training process, almost everything that I'm saying comes from a special education law. And so I'm able to cite that and provide that to staff and parents. And so IDEA is the main federal law. So that's Individuals with Disabilities Education Act. And this ensures that students with disabilities are provided a free and appropriate public education that is tailored to their individual needs. This is the primary law for special education, and there is a link on your slide here in case you needed to access any of those laws and regulations. It's a great place to start if you have questions. Certainly can be overwhelming if you are in a position where you're confused and upset by the process, and then you open up that law. That may not be the best way to go. Feel free, of course, to email me or Family Matters and get some guidance on where to go. But that's a great place to be familiar with if you're just starting your special education journey. You may want to be familiar with those laws. We also utilize the Rehabilitation Act. That's 504 plans. This is a civil rights statute. And so this covers people of all ages with disabilities that substantially limit one or more major life activities. And so when we're talking about school districts in 504, we want to focus on accommodations. What is a reasonable accommodation for a student? And so that's what those should look like. When we talk to families about whether a 504 or an individualized education program, an IEP, are appropriate, we're often talking about whether or not they need accommodations or more than accommodations. And so once they need more than a list of accommodations, 504 law no longer really is enough to support that student. And that's when we're going through that IEP process through IDEA and not a 504. And then lastly, up here, we have Illinois Administrative Code. So Title 23 of the Education and Section 226 for special education both have a lot of additional laws in them. You will notice if you dig into this at all that a lot of what's found in Illinois Administrative Code cites back to that Individuals with Disabilities Education Act. We do have a couple places where Illinois provides additional parameters, so it kind of narrows down that federal focus. And so it's a little bit different, but a lot of it just goes back to IDEA. All right, so procedural safeguards. What are they? When should I get them? And what if I don't have them? So the reality is that your procedural safeguards are your rights. This is a parent, a student's rights written into law about special education and what to do when we're creating a plan and what to do if we disagree on a plan. And it's all outlined in there. However, in my experience, I age myself every time I tell this story, but in my experience, procedural safeguards have kind of become like HIPAA packets. When you go to the doctor's office, you're signing off, you're putting your initials, you're saying, oh, I don't need them. I've received them. Someone went through them with me 20 years ago. And I'm just as guilty as the next person. A packet that talks about privacy information when I go into the doctor's office is not my priority at that moment. And so, yes, I've seen them before. Yes, I'm vaguely familiar. And so I initial, but I don't often reference back to them when I'm done with my appointment or when there's a problem. And I think that is kind of how procedural safeguards become with special education, particularly if things have been going fine when a student is young, or maybe it was reviewed in early intervention and they say, oh, do you have those? Do you understand those? And we're nervous and we're in a meeting and we're just sitting there and we're like, yes, we have that. That's fine. And we move on. You're supposed to get a copy of those, or at least acknowledge that you have a copy of those at the beginning of every IEP meeting. There is a box or a form as part of a district's process going through the IEP that requires that a parent acknowledge that. So please, please, please know what they are. Know where you can get a copy of those, which there's a link up here that goes to the ones specifically for the Illinois State Board of Education. Most school districts just provide that direct paperwork to parents. Occasionally I'll run across a district who has printed off something different, or they have one that they created with their district information on it, and all of that is fine. It should all be the same. And then in the bottom, you'll notice that there's the actual law citation that talks about those. So if you were curious where all that information came from, then you would go to that particular law. So when you read through the procedural safeguards, if you were to click on the link on the previous slide, the very first thing that it talks about is prior written notice. And this is something that is written into the law as a requirement. So what it says is that the parents of a child with a disability are given this very specific information anytime a district proposes to initiate or change the identification, evaluation, or educational placement of the child, or the provision of FAPE. So that's a free and appropriate public education, or if they're going to refuse to do those things. So this is a huge key in what we do, because it really breaks down that the law requires that we be given notice, us as parents, that any decision, any change to that IEP contract will be done in writing. And so, excuse me, it's super important to understand what should go into that so that you know what you are supposed to be receiving, what is supposed to be provided. Also, it's a wonderful tool when you're in a meeting and you disagree. So it's one of the first things we talk about when we're in a meeting, and a parent and a district both have differing opinions or different understandings of something, or a parent is asking for something and the district is saying they cannot do that. What we typically do in that circumstance, like a parent will tag me in and they'll say, Laura, what should we do? We can't come to an agreement. And I'll say, it's time for prior written notice. We need to be given whether or not they're going to make the change or refuse to make the change, and it needs to be in writing. And that kind of dictates how far we go after that. So the why is important, why we're going to change something, and why we're not going to change something. So we want to make sure that we have that and it's clear and it's in writing. And once we have that, we are better able to, make further decisions about procedural safeguards or about, how we want to move forward. So what goes into prior written notice is very specific. Illinois has determined that your IEP, the actual contract IEP document, can be considered prior written notice as long as it has all the appropriate pieces of it. And so sometimes that happens and sometimes it does not. So when you ask a district for prior written notice, sometimes they don't even know what that means, because they have just been providing copies of the IEP at the end of every meeting. They know it's part of their process that they go through. And if it has all these pieces in it, it counts. It's prior written notice. The problem we run into is when we don't have each of these pieces, then the IEP isn't the prior written notice, and we need to request more of that. So here are the pieces that have to be included in this. It has to have a description of the action proposed or refused by the agency. So what did we ask for? What is the district asking for? What are we wanting to do? It has to have an explanation of why the agency is proposing or refusing to take that action. So the parent requested this. We are saying we cannot do this and why. This would then include a description of any evaluations, assessments, records that was used to make this decision. So very frequently when parents are working with me as an advocate, we're talking about what the data looks like. So what do the evaluations say? What does the data show? What do benchmarks show? Because that's the data that's going to be used in order to make changes to the IEP. So the student is struggling, and this is the data that shows us why. And so that's also the data we want to see in a prior written notice. So not just we think this or we feel this, but this is what the data shows. It also must include a statement that the parents of a child with a disability have protection under their procedural safeguards of this part. And if this notice is not an initial referral for evaluation, the means by which a copy of a description of the procedural safeguards can be obtained. And so that's when I was kind of talking earlier about HIPAA. So you will initial something in part of your meeting saying or sign saying that you received those procedural safeguards. And so that's something we do out of habit, but be mindful that that is the school meeting their obligation to provide you with that information. So it has to be on there in order for it to be considered prior written notice. There also needs to be sources for parents to contact to obtain assistance in understanding their rights, a description of other options that the IEP team considered and the reasons why those options were rejected, and a description of other factors that are relevant to the agency's proposal or refusal. So why is the district saying we need to do this, or why are we not going to do this? All needs to be in there. Typically, we're finding the bulk of this information in the additional notes section, and it does require a little bit digging around. We want to make sure that we're looking at the whole IEP. Sometimes that's 20 pages, sometimes that's 200 pages, and it can be a lot. So if you're ever concerned whether or not something constitutes prior written notice and you've pulled up this checklist and you just don't know, or you're confused or you have questions, you absolutely can reach out to your district and ask them, say, yeah, I know I'm supposed to get this description of the evaluation procedures that were used to make this decision, but I don't see that anywhere on there. Can I get that? If you need further assistance, obviously you could call out to my program at IGAC or with Family Matters to get some further guidance on what we need to get in order for prior written notice to be official. The next thing in your procedural safeguards is parental consent. And I think that it's super important for everyone to understand when a parent is actually consenting, because it's different in each state. So IDEA has kind of given some guidance as to what parental consent means. And then Illinois has kind of pared that down into what they believe a parent needs to sign to. And it causes a lot of confusion in meetings. Very frequently, parents will call me and they'll say, well, I didn't sign off on the IEP after the meeting because I disagreed. And so what that tells me is no one has explained to them what their parental consent entails. So I want to take a minute and make sure everyone kind of understands what that means. So when an IEP is first being developed, the very initial evaluation is being done, a parent provides consent to the evaluation specifically. So this would be domain paperwork that goes through each area that the school and the parent believe needs to have further evaluation in order to determine whether the student is eligible for an IEP or not. So that consent is just for those evaluations. It just says that I give permission as a parent for the district to do those evaluations. And that's it. That's that first piece. The second time a parent will sign something that is consent is once a student is eligible for special education, then the parent provides a generalized consent that says, I agree that my student is eligible, and I agree that we're going to provide special education services. After that consent, at each IEP meeting, there is nothing required from a parent to sign as far as consent's concerned. There are a couple other times because Illinois has interpreted that federal law as that once the parent says, yes, we believe the student needs special education services, then the IEP team as a whole, which is outlined in law also, makes those decisions. So the team includes the parents, but it also includes the district. It includes related service providers. It includes anyone who was brought to the meeting who has, knowledge of the student. And so that's where I feel a lot of families get frustrated, because you're going into a meeting, and I have been to IEP meetings as a parent and as an advocate, and I can tell you the dynamic of that meeting when you're going in feels like 1 versus 10. You're the parents, two parents and an advocate. You're still, 3 or 4 people, and the district has a lot of people on the team that are very specifically outlined. And so it feels like, you're kind of outnumbered at that point. And so that's when parents will reach out to me. They'll say, oh, well, I didn't say yes or no to that IEP because I didn't sign it. And so there's more to it than that. You do not need to sign to give consent to that specific IEP. So if you disagree, then we need to look at other options in our procedural safeguards, as opposed to just saying, well, I did not sign. The other time you will have this is during reevaluation. The process every 3 years at a minimum gets redone. So it's not an initial evaluation anymore. It's a reevaluation, but it's still the same. A parent signs consent for the evaluations, which areas we're going to look at and create and develop a plan off of what we're going to do. If the student is eligible at reevaluation, then we need to sign again that consent that we agree that a student needs special education services. Again, not specifically the IEP, but just in general, they need special education services. A parent does have the right to revoke consent for either of those things at any time. So what that means is you're mid-evaluation and you don't want it done anymore, a parent can revoke that. If we are in an IEP meeting and we, don't think the student needs it anymore, you can revoke that. You have that right. Please do not take that right lightly, though, because pulling parental consent for special education services really severs the district's obligation to provide services to the student under IDEA. And it can put a student in a really bad position and a parent in a bad position unless we've really thought through why we're doing that and what the benefits and the downfalls are of that. So if you're ever in a position where you're thinking you need to revoke consent, please talk to somebody and make sure that that is the most appropriate course of action. There are a couple other times that you will provide signatures as a parent, and that's attendance at IEP meetings. So when you get there, you'll sign and say, okay, I'm here, and that's what that means. It's just attendance, that you were present, and then you may waive rights. So might be 10-day notice of meeting, attendance of an IEP team member. When you're providing a waiver, then your signature is necessary also. All right, so parent participation in meetings. So yes, it stinks. You feel slightly outnumbered. You're super overwhelmed. I'm going to tell you right off the bat, it doesn't matter if the relationship in between the parent and the school district is amazing or whether it is stressful, because I have been for my student in IEP meetings that were amazing. Absolutely amazing meetings. They were talking about how wonderful he was doing and how he had picked a career path and he was really doing fantastic in his classes. And in that moment, I'm so overwhelmed with happiness and so grateful that he's gotten where he needs to be, that as a parent, I wasn't a very good participant in those meetings. So that's why we tell people, feel free to take someone with you, bring someone to take notes, whether that be an advocate, a friend, a spouse, somebody to kind of be with you so you don't feel like your participation is so outnumbered, but also to help navigate things if you're emotionally invested in this kiddo. And so it's hard. It's just super, super hard. Even when it's not bad news, even when it's good news, I'm telling you, it's overwhelming because, your heart's there in that meeting. That's your kiddo. And so you do have a right as a parent to be a part of the IEP team. That is written into law. So your participation in that meeting is very specific in the law. The school district is responsible for scheduling the meeting at an agreeable time and place so that one or both parents can attend, and 10 days notice of that meeting has to be provided in writing. This is another one of those times where you might waive, like I was talking about a minute ago. A parent might sign a waiver. So maybe there is a more emergent situation. We're having a behavior issue, or a student is sick and is missing class, and we need to talk about how to do those things. And you don't want to wait 10 days. And the district has, an appointment available in 2 days. They can get the whole team together. That's wonderful. You're able to sign that waiver. There's a lot of times when that makes sense to sign that waiver. But just know that under this law, it's 10 days notice. A couple other procedural safeguards that are noted. So if you were to pull up the procedural safeguards form from your district, or the one I linked earlier, you'll notice there's a couple other things here that I'm not going to dive into super deeply today, because this is an hour-long presentation, and a couple of these could be a day or multiple days if we were to really dig into them. The first one is evaluation. So the student has the right to be evaluated. They have an initial evaluation for special education, and that 3-year evaluation that we talked about earlier, at a minimum once every 3 years, to get updated data. The third time that is kind of dug into in the procedural safeguards is independent educational evaluations. And so after a district evaluates a student, if a parent doesn't think they looked at all areas of suspected disability, or they believe that the results of the evaluation are not reflective of their student for some reason, they have a right to an independent educational evaluation. That could be at a parent expense, could be at the district's expense. And again, certainly if you're in a position where you want to do that, you'll want to make sure you understand all the ins and outs of independent educational evaluations before proceeding. So if you disagree, that's a right available to you under the procedural safeguards. There are also some additional pieces of information on discipline. The procedural safeguards outline the definition. It talks about what long-term suspension means. And it also goes into manifestation determination reviews, which are meetings that need to be held if a student is suspended 10 or more days, in order to kind of look at that. Like, is this a part of the disability, or is it not part of the disability? And what do we need to do to make changes so that we can, work with the student and lessen that discipline activity, lessen the suspensions. And that is also a very, not complicated, detailed. There's a lot of detail when it comes to manifestation determination reviews. I think that's one of the areas we answer a lot of questions about, is discipline. We cannot always take every discipline case within our advocacy, because it needs to be tied to a student with a disability. But if you find yourself, again, in that position where you're wondering what to do, when it comes to discipline, start with your procedural safeguards. If you need any further guidance, certainly you can reach out. All right, so the next slide says dispute resolution options. So you find yourself that you've gone through the process, you've gone through the IEP process or the evaluation process, whatever it might be, you're in that meeting, and a parent in a district disagree. They disagree with whatever that might be. We look at that in two different ways in my program. The first way I look at that is, I say, is this a matter of procedural disagreement or procedures not being followed, or is this something more substantive? So are we disagreeing about how to do something or why to do something? Then that falls more into a substantive category for me. Regardless of whether or not we're looking at this and saying, we disagree. Maybe we disagree in this meeting today. Sometimes it's okay when things are, people are bumping heads, to say this meeting needs to stop. We all need to gather some more data, or we need to gather our thoughts, or we need to gather our ability to not be angry at each other, whatever it might be. And we'll continue this meeting. We also can request a meeting. So a parent has the ability to request an IEP meeting at any time. When that request is made, the district has certain parameters as to whether or not they can accept that request, if they want to hold a meeting, when they hold a meeting. There's some law to support that also. So things like knowing how many days a district has to respond to that. And, they have to respond in writing if they're going to deny it, but they can respond with a, notice to have a meeting. There's a lot of pieces of that. but it's the best place to start. The second thing here is state-sponsored IEP meeting facilitation. We'll talk about that a little more in a minute, but basically what that means is, we have someone from the Illinois State Board of Education coming into our meetings. Could be the filing a state complaint, and I'll talk about that a little more. Again, that's back to when we're talking about procedural. State complaints are done differently in every state. And in Illinois, I find state complaints to be most effective when we have a very clear law violation. So, for example, a parent is supposed to get draft documentation, draft documentation of anything that's going to be discussed 3 school days prior to an IEP meeting. So if a parent doesn't get that, they have the option to say, hey, I want to reschedule because I want to have that paperwork, or they can go ahead and hold that meeting. And my job as an advocate is just to make sure they understand what those rights are, and then they make those decisions. But a lot of times we have procedural things that happen frequently, not ever getting documentation before a meeting or things like that. And then that could be resolved through a state complaint investigation process. The next one is mediation and then due process, and I'll dig into that here in a couple slides a little more. So with that first thing, requesting an IEP meeting, I want to jump into that just a little more. So anyone in the IEP team can request an IEP meeting at any time, including the parents. This makes sense. It's your first line. And again, it is the quickest way to resolution is to get a team together where everyone decides, because then we can implement it quickly. The district has 10 calendar days to respond to the request. One of the things that I find annoying after all these years in special education is that you'll notice in the law, sometimes I'm saying 10 days, sometimes I'm saying 10 school days, sometimes 10 calendar days. That really matters in a lot of these discussions that we're having, because the difference between 60 school days for evaluation, that's almost 3 months. That's not 60 calendar days. And so it's important that you understand as part of your rights when those time frames are necessary. So in this case, when we request an IEP meeting, the district has 10 calendar days to respond to that request. If the district disagrees with the need for an IEP meeting, they have to provide that rationale in writing. If they agree to it, then one needs to be scheduled. It can be 10 days notice, or like we talked about earlier, you could waive that 10 days notice. You'll see the law citation where that information comes from in case you're ever needing that. And again, requesting a meeting should always be the first thing you do when you disagree with something in the IEP or the implementation of the IEP. Documenting the request and the district's agreement or disagreement with the request is super important in these next procedural safeguards that we're going to talk about. So you've requested a meeting, you've sat down, you've made all of your concerns known, whether that be district concerns or parent concerns, and you've come to the table, and we want to make sure all of that is in writing. If at the end of that meeting you still don't agree, we end the meeting and we consider which procedural safeguards are most appropriate going forward. So remember, that's the first thing to do because it's fastest. We can get in 10 days or less. The next couple things that I'm going to run through are not as quick. And that's fine. It's okay. They're designed to be that way. The first thing is facilitated IEP meetings. So a facilitated IEP meeting is when the Board of Education provides someone who's trained to assist in effective communication. So this can be used for any part of the IEP development when the district and the parent disagree, but participation in facilitated IEP meetings is voluntary. So if a parent requests that and the school doesn't want to do it, they can decline, and vice versa. In my experience, the facilitated IEP meetings are most effective when the primary issue is communication. So it happens. It absolutely happens. We're humans. We're emotionally invested. Districts are emotionally invested. Our feelings get hurt when people disagree with us. That is human nature. And there are often times in these meetings where communication is the key, where a school district is talking about a BIP and a parent really wants something in place for behavior. And those are the same thing. One of those is a behavior intervention plan. And so sometimes it's language, sometimes it's acronyms. The alphabet soup gets us sometimes. And when we're heated and we're trying to get something and we think we're right, it's sometimes hard to see eye to eye. And so that's when a facilitated IEP meeting can be the most effective. If you wanted to request a facilitated IEP meeting, the directions are at that link on the bottom of this particular slide. The second thing is those state complaints here. Not the second, it's the third, because we're going to request an IEP meeting. We're going to decide whether or not it can be resolved. If it's a communication issue, that's your facilitated IEP meeting. The third thing we're going to look at is always, is it procedural or substantive? And so when it's procedural, like we're talking earlier, if you were not getting your paperwork in time, if we are not having IEP meetings in the right amount of time, or evaluations are taking longer than necessary, that is when this is most effective. So can we say on blank date, the district did X, Y, and Z, or did not do X, Y, and Z, and the documents are attached? That's kind of how I mentally say that to myself. Well, is this something where we can say it happened on this date? This is when they denied this. This is what happened. And this is what we think should have happened. If that's the case, then we should be looking at state complaints. Any person or organization can file a state complaint within 1 year of a violation. So once the violation occurs, you have 1 year in order to file a state complaint. And the Illinois State Board of Education will take up to 60 calendar days to investigate that allegation and provide a report of findings. So they'll get information from the complainant, they will get information from the district, they will review documents, and they will say, yes, we believe that this happened and it's founded, or no, we believe it didn't happen and it's unfounded. And with that, they'll provide recommendations on how to rectify anything that was found. So it's a great process, again, particularly for procedural, but again, 60 calendar days is a long time. So remember, that is why when we're looking at things, we want to start with that IEP request, because 60 days to get to a resolution may not be enough, and then a state complaint may not be the best course of action. So we've looked at all those different things. We want to make sure that we have an overall understanding of what mediation and due process are. So again, I'm not an attorney. I do not do mediation or due process as part of my job, because we believe and we know statistically that it's more effective if an attorney is representing. But it's good to know what this means. So mediation is a voluntary process that brings parents and districts together with an ISB appointed mediator in an effort to come to a formal agreement. So parents say to me all the time, that sounds an awful lot like a facilitated IEP meeting. And it is. The difference is when we're in a facilitated IEP meeting, the person from ISB is just helping the team communicate. They're doing things like they'll put up a piece of paper or a dry erase board, and we'll go through things and organize thoughts and help communication. With mediation, the visual that I always keep in my head is we've got the district in one room and the parents in one room, and then they come together and they meet with the mediator from the Board of Education, and they try to come to a give and take type of agreement. So maybe we're not going to absolutely agree on this, but maybe we're going to agree to collect more evaluations on this, or maybe we're going to, we're not going to do this, but we certainly can provide this. And so they come to some kind of a formal agreement in that mediation, and it's legally binding. There's a piece of paperwork, it requires signature, it's as formal as a mediation agreement can be. This can be used for any part of the IEP development when the district and the parent disagree, but participation in mediation is voluntary. So when I look at these as an advocate, in my experience, this is most effective when both parties understand the issue but can't come to an agreement. So when we're talking about a facilitated IEP meeting, that's that communication, not being on the same page of what the issue might be. Mediation is going to be more effective if we say we both agree that the student needs some additional reading support, but we don't agree how to do that. A parent might want a more specific program for a learning disability, and a school district might say that type of program is embedded in the reading program we already have, so we would like to provide that. And so mediation is a discussion about how to resolve that, and that's when it's most effective, again, in my opinion. Both the parents and the school district can make this request, and it has to be scheduled in a timely manner. So if you wanted to request mediation on your own, you would click on this link. The directions are there on how to file that. Again, if you were to call me and say, hey, I'm considering mediation, these are the questions I would go through with you. And then I would tell you, I strongly advise discussing with an attorney because of that success rate I discussed earlier. All right, so due process. So maybe mediation isn't the way to go with this. Maybe you do mediation and it's unsuccessful. You can't come to an agreement. Due process is more visually like a court type setting where we have a hearing officer who's going to make the decision. So with mediation, we're trying to come together. We're trying to come to an agreement. We are saying this is what we feel and think, and we're hoping to come to some middle ground. Due process is more presenting evidence to a hearing officer and saying, this is what we think. And then the other side presents what they think. And then someone else makes that decision. So it's used to resolve disagreements relating to any identification, evaluation, educational placement, or provision of FAPE to a child. So again, we're back to this is most effective when it's substantive and we need someone else to make the decision. We cannot come to an agreement. A parent or a district in limited circumstances can file due process within 2 years of when you knew or should have known the district violated the student's rights. And then due process results in an administrative hearing are similar to a court hearing, and the orders remediate action. So at the end, there'll be a court order that says, this is what we have agreed to do. This is what we're requiring each person to do. And so that is very similar to what you would experience if you've ever been in a courtroom. The link at the bottom of this page takes you to how to file for due process. Other things to be aware of that are part of your procedural safeguards. The first one is placement disagreement. So if you disagree with the IEP team's decision to change a student's placement. So remember, placement isn't physical location. When we're talking about special education, placement is the percent of time that a student spends in a special education setting or with special education support. So that doesn't mean like we're moving classrooms or we're moving school districts. Placement is just when that percentage changes. And so when we disagree about that, you can file mediation or due process and invoke stay put. So that means that the new IEP that we can't agree on is not in effect. And we're going back to the previous IEP in order to essentially freeze that placement until we're able to utilize the mediation or due process for that dispute resolution. So to make sure that the student stays where they were until we can come to an agreement. Again, remember, these are time sensitive. This is one of the things that the advocates are vividly aware of when a parent first calls in and they say, hey, I disagree. I don't want my student to be changed to this placement. Or a district calls and they say, we really think this placement is best for a student. And we're trying to decide what the next steps are from an advocacy perspective. That 10 calendar days needs to be taken into consideration. So the meeting, this was decided, and there's a disagreement. We only have that 10 days to file mediation or due process in order to freeze that placement. Another thing to be aware of is access to records. So as part of rights and procedural safeguards, the school district has 10 days from a parent request to provide access to students' educational records. It can be extended by 5 days if needed, and there's the law you can reference if you need to access those records. We strongly suggest looking up who your district's record keeper is and making the request in writing to them. Now, that's not required, but for most districts, if you pull up their webpage, you're going to find, if you dig a little bit, either a records officer, a FOIA officer, that's your Freedom of Information Act. Those are people who have been designated and understand the timeframes and the laws of getting a parent access to their records, where if you just send that to a teacher, they may not be familiar with that. And so it could delay the process a little bit. So that's our recommendation, although it's not required. So know that you have the right to that. The next slide always kind of makes me giggle a little bit. This is a peek inside my brain. And so for those of you who are visual people who are in the process of a disagreement with a school district, no matter which side of that you're on, this is what my brain is doing when you call me. And so it kind of summarizes all of those procedural safeguards that we were just talking about. So the first thing I'm asking is, have you had an IEP meeting to discuss the concern and document it through prior written notice? So if the answer is no, then we're going to request that IEP meeting. If you feel the issue is communication, you're going to utilize facilitated IEP through ISB. So that's the clear path if you have not had it. If a parent calls me and they say, yes, we've had a meeting or we've had several meetings and we can't come to an agreement, we have it all in writing, then I'm going to ask if the concern is procedural or substantive. I'm probably not going to use those words, but we're going to dig through it together and figure out, is this something where a law is violated clearly and it could be resolved through a state complaint? If not, if it's more substantive, remember we both understand the issue. We may disagree on the issue. We may disagree on how to do that. Then we're going to look at whether mediation or due process is most appropriate. If that's the case, I'm probably going to advise you to speak with an attorney. But then those are your two options to resolve that dispute. Also, I want to note that if mediation has been filed and it was unsuccessful, meaning there's no mediation agreement, no one signed anything, we couldn't come to a resolution, then you still hold that right to due process. So this is kind of how I think my way through your procedural safeguards when you call me. And so I want people to have that in case that's the way that you learn or think of things in order to kind of come to a decision on which one of your procedural safeguards might be most appropriate for you. All right, last thing I have is some time for questions. So I don't know, Abby, if you want to start with the chat and let me know what you need there.
Yeah, give me just a second.
No, you're fine.